Welcome everyone to the Institute for Environmental Futures seminar series. Today's seminar is Law is Not Planning by Dr. Stephen Riley. Dr. Riley's research connects the philosophy of law and future generations, specifically how legality can form part of intergenerational justice, especially how law can contribute to limiting the demandingness of intergenerational justice. Conversely, how problem futures provoke questions about law survival. He has also written extensively on the topic of human dignity and law, producing a monograph and several articles in leading journals. His specific concern is of the foundational claims associated with human dignity. And with this short introduction, please.
Wonderful. Thank you very much, Emilio. Thank you very much. Thank you for being very patient with me. I was quite difficult to pin down and did lots of things too slowly, and you've been remarkably patient with me. So I want to say a special word of thanks, but also thank you to the Institute for having me. I've been to a few, not as many as I'd have liked, but a fair few of your events, and they're all pretty wonderful. So it is a privilege to be part of this series. So thank you very much for having me, and thank you all for coming along, friends old and new. I'm going to establish for you in the next 40 minutes a bit of a dialogue between general jurisprudence, theories of what law is, and climate law, climate justice on the other hand. And I want to tell you that these two things are going to illuminate one another, or at least that's the plan. I'm going to tell you something about how we characterize law and whether we should characterize law as planning. And I'm also going to try and make sense of the fact that you and I probably share the intuition that climate cases in courts, while important, symbolic victories are not going to be the whole story when it comes to climate justice. And I want to try and unpack for us today why those climate cases, while important and symbolically very heartening, are not going to be the whole story when it comes to climate justice. So let me put that a bit more systematically. Is law planning? And a spoiler alert, law is not planning. It has some analogy, some parallels with planning, but broadly speaking, I think it's a mistake to think about law as a form of planning or analogous to the planning that we do as individuals, or indeed as we do as a society. And I'm going to do that through a dialogue between a general account of law and some climate cases. I'm going to start with something about presentism. I'm going to give you an introduction to a couple of interesting cases, I think, do a bit of philosophy, tie it all together, and then we can go home. Let me start with a nice philosophical, theoretical question or theme to set the tone. Is law presentist? I'm not asking whether law is conservative. I think law is a conservative institution. What I mean by that, and what we mean by conservative, I'll come back to. And it's going to be quite important to try and pin that down. But I'm not asking whether law is conservative. I'm asking whether law is presentist. What is presentism? I'm going to treat presentism in a very loose and not very systematic way as a syndrome of errors, biases, mistakes, where we illegitimately privilege the present over the future. So I'm not going to be very systematic here. I'm not going to be very scientific. It's just a broad collection of temptations, tendencies to privilege the present over the future. We do this as individuals. It's got various names, various elements to it. You could just call it weakness of the will, where we decide we're going to go to the pub tonight rather than work on the article or read a book. And we're kind of privileging the pleasure and the hit today rather than actually the stuff that's probably more important, but is sometime in the future and therefore doesn't seem quite as real, doesn't seem quite as pressing. We do this as individuals. And I think philosophers and economists give us a couple of models mechanisms to try and make sense of this, this syndrome, this collection of errors, this collection of mistakes. Two elements of this are discounting and free riding. So briefly, what are discounting and free riding? Discounting is just putting a lower value on things in the future. Just saying that our future interests or our future goals, future values, future people are less important. That could be a future us, are less important than the present people, present pleasures, present values, present us. There's a wrinkle here insofar as economists will tell you that sometimes it is rational to discount. Right? For various reasons, it might be rational to discount because various costs might fall over the future, and tomorrow might be quite different for you. I don't want to be too pessimistic or too dark here, but you don't know what's going to happen tomorrow. So maybe there are good reasons to be presentists and to discount the future. But in the main, it is an error. It's a mistake. It's pathology. Because you are as valuable tomorrow as you are today. Other people will be as valuable tomorrow as they are today. So discounting them and you is a mistake. Free riding is a different kind of mistake, different kind of fallacy. Free riding is where you have a common good or a common service that is a public good, public service, which is tolerant to individual contributions. So the bus service, train service is tolerant as to whether or not you pay. It will go on running tomorrow if you don't pay. And again, the economists will say that that's actually the rational thing to do is to free ride, because everyone's a winner. The public good or the public service will carry on tomorrow. It is tolerant to whether you pay or not, and you've got more money in your pocket. That is Pareto optimal. That is the best rational outcome for an economist. Do the free riding. Public good, public service carries on. You've got more money in your pocket. The problem is, of course, that lots of public goods and public services will tip into a state at some point where they aren't tolerant of free riding. A lot of public goods and public services will tip imperceptibly at some point into a situation where they're not. That, of course, is also going to be true of the climate. The climate is public goods, public service. We can build stuff into it, and it's pretty tolerant about what you and I do, and it's pretty tolerant about what individual states do. But at some point, it might tip. It is tipping. It has tipped into a point where it's going to stop tolerating that. And so that leads me to the question of scaling up. We as individuals have presentist biases, tendencies, impulses. Do these scale up to the state, to a collective level, to an institutional level? And most economists, politicians, political scientists will say yes. States discount, states free ride, states treat common goods, common services as tolerant to their individual contribution, and states will discount the future. Well, they'll put more value on people today than on people tomorrow. That's what our politicians do when they make promises in elections. They will start to make wild promises to you, and they'll keep the costs down the road. If they have to pay for it, hopefully they'll have to pay for it somewhere down the road. So the point is that presentism is something that we as individuals do, and it scales up to a collective level. So, question. Now the question. Is law presentist? And the annoying answer is probably yes and no. Law isn't presentist in this sense. Law is actually an institution for offsetting or dealing with our presentism. Law is there as a kind of backstop in the back of our minds that says, okay, you might want to steal the chocolate bar now, or you might want to steal the car, but actually, think long term. You might end up in prison, or this is going to be bad for you in the long term. Look, the law will set. Hopefully we don't wander around worrying whether what we're doing is legal or illegal. But there may come a juncture in your life or somebody's life where they have to think, well, what's the law think about this? And the law should help them, scaffold them to think in a long-term way and not in a presentist way. So actually, law is not presentist. Law is our best institution for offsetting individual presentism and institutional presentism. areas like constitutional law, administrative law are there to speak to our lawmakers and our politicians and to stop them being present and say, law says to our political classes, you can make all these promises, but you are going to be held to them. Whatever you explicitly commit yourself to, we're going to hold you to account for that sometime in the future. And law is there to stop that political presentism. So law is not, it's a way of offsetting presence. But, and there's a big but, law really is presentist as well. What law does is entrench certain kinds of stable, reasonable expectations, and I'm afraid I'm going to put the bunny ears on reasonable for reasons that might come clearer later. But law kind of stabilizes certain expectations. It stabilizes our expectations about what we can expect from other people. It stabilizes our protection of the body, protection of our property, and it stabilizes the expectations and the interests of people today. And of course, that's going to be crucial to my concerns in the next 15, 20 minutes. It really does entrench the interests of people who are living today. And it's very rare for law to be an instrument to take the interests of future people and make them trump or override the interests of people who are living today. So, a philosophical conundrum, not necessarily a contradiction, but a bit of a conundrum there. Law isn't presentist, and it is presentist as well. Okay, so that's the philosophical scene setting. Lest you think I can only speak in abstractions, I'm going to pretend briefly to be a proper lawyer, if only to break it up a bit and give you something concrete to think about. I'm going to give you two cases. Why am I going to talk about cases? Well, the cases in courts are where we operationalize law. We pass laws, we sign treaties, but it's really in the courts where these treaties, these acts of parliament, they really are operationalized, they're put into force, they're given specificity, and they entail specific rights and responsibilities for specific people. So we need to look at the courts. But also we need to know the story about what the courts do and how they do it in order to understand and enrich this tension between law's presentism and its anti-presentism. And I'm going to give you two cases. One, the first one is what has come to be termed a climate-aligned decision. That is, it's a pro-sustainability, pro-climate mitigation, climate adaptation case. And I'm going to give you a non-aligned case because it's not all good news in the courts. So for the sake of balance, this is relatively arbitrary, but I want to give you a climate-aligned case, this one, and then I'm going to give you a non-aligned case, which went, as it were, against the climate and against the environment. This case, KlimaSeniorinnen and Switzerland, was decided just this April. KlimaSeniorinnen is a large Swiss group, charity, NGO of roughly 2,500 Swiss women, most of them over the age of 75, who argue quite persuasively, as it happens, that they are disproportionately impacted by climate change. Both because of their age and because of their gender, they are specifically, they feel a disproportionate impact from climate change. And the claim in the European Court of Human Rights is that they are experiencing that in part because of the failures of their state, namely Switzerland. The question for the court is this: has there been a violation of human rights? And specifically, at least for our purposes, has there been a violation of the right to life, Article 2, and has there been a violation of Article 8, that is the right to protection of their private and family life? Now, given that I'm not really talking about this case for really specific forensic legal reasons, I'll just shoot to the outcome. There's not going to be any surprise here. They won. In a sense, that was a surprise, though. If you were a betting person, you would have bet against this being a successful case for certain kinds of procedural reasons. But anyway, they win their case, much to the chagrin of Switzerland, who are very, very angry about this. But they win their case. So Switzerland is violating the human rights of the women represented by the applicants in this case. Switzerland is engaged in an ongoing violation of Article 2, the right to life, and Article 8, the right to private and family life. Why are they in violation? Because they are not doing enough to mitigate climate change. Switzerland is committed to the Paris Agreement. And I'll use the shorthand of Paris from now on. Paris Agreement 2015, they've signed Paris, which means that they have made a nationally determined contribution. They've publicly committed themselves to mitigation. And accordingly, they argue that there should be no violation of human rights, no finding of violation. They're committed to Paris. They've got a plan for mitigation. And this is important, Paris allows a great deal of flexibility between different states. Because of the principle of common but differentiated responsibilities, different states are allowed to commit to different levels of mitigation. There is no one-size-fits-all obligations under Paris. Each state, given its different level of development, given its different economic and social conditions, has to commit itself in a way that is appropriate for them. It has to be ambitious. It has to be an ambitious plan under Paris. But nonetheless, because of the principle of common but differentiated responsibilities, Switzerland, like every other state, it is free or has a relatively free hand to decide how it's going to mitigate its climate footprint. That's what Switzerland says. We're committed to Paris, so there's no case to answer. The court says no. Sorry, we're not going to buy that. The fact that you're committed to Paris and you've made your nationally determined contribution to Paris is not enough. We're deciding whether you're violating human rights. We're going to look at all of your policies, all of your legislation, all of your law in the round and make a judgment. So we don't care whether you're committed to Paris or not. We've looked at everything that you're doing. We've decided that you're not doing enough. So the key to the case is a question about, it's certainly not a scientific question about whether you can correlate climate change, the actions of the Swiss state, and what's being experienced by the Swiss applicants. In a sense, everybody agrees that anyway, that the science there isn't controversial. The point is that what is relatively controversial is that there's a finding against the state, but just not having joined up all reasonable policy. It's the unreasonableness of the steps that Switzerland's taking to reach its goals that holds it in violation of the convention. There is a lack of specificity. There's a lack of clarity. There's a lack of detail in terms of how Switzerland is going to realize its overall goal of net zero and its specific goals under Paris. It's that lack of specificity, the lack of reasonable steps by the state that's key. The rest of the evidence is not really contested. So the state's not being reasonable. But what's the key to the case? What do we take away as people concerned with the philosophy of the future and the climate and the role of the court and all that? The really important bit for our purposes is the principles and all the principles that are swimming around here. What principles were swimming around in the case? Sustainable development, common but differentiated responsibilities, precautionary principles. That's all the kind of principles that the applicants brought to the table. What did the state come back with? Separation of powers, parliamentary sovereignty, the supremacy of parliament. The point is that the case is never just about rules and evidence. The case, certainly a case like this, is also about principles. And these really important principles that you will have encountered, I'm sure, in various contexts: sustainable development, common but differentiated responsibility, parliamentary sovereignty, separation of powers. None of those principles is going to be a knockdown winning principle for the party, but you can't make a decision in a case like this without those principles. The question I'm going to come back to, but I want to leave this case here, leave it hanging in a sense, is why aren't principles, why isn't there a master principle that will just come in and decide the case or decide everything in a way that is aligned with the climate? How come, given the urgency of the climate emergency, how come there isn't a principle that just parachutes in and solves everything or insists that everything must be aligned with the climate? And the answer is that law doesn't work like that. And there are no master principles. And you're never going to get a situation where a master principle is parachuted in and just answers it. That's also illustrated, but in a different way in Sharma. I'm going to have to be a bit less detailed here. I got a bit overexcited with the Swiss case. I'm going to have to be a bit more professional. Okay. Sharma. Old-Julie Sharma was at the time she was a teenage Australian. Her and her friends brought a case against the Australian government. What do we know about Australia? Well, behind the sunshine and the smiles, Australia is a shambolic, shameful addict. It is addicted to coal. And this was an attempt to try through the courts to try and decouple Australia and its economy from coal. They argued, Ms. Sharma and her friends, they argued that the Australian environmental minister had a responsibility to children in particular, a duty of care to children in particular, not to grant any more coal mines licenses. It went through the courts and it went the way of Ms. Sharma and her friends right up to the federal court. All through the lower courts, the finding was for Sharma and her friends that there is a duty of care. Australia should be decoupling itself from coal. Australia is damaging the health directly of children in Australia by licensing coal mines and indirectly harming all future Australian children by contributing to anthropogenic climate change. We get to the federal court and it's turned on its head. There's no duty of care. Here are the reasons why there is no duty of care. There's an argument for parliamentary sovereignty, the separation of powers. It's a political matter, in essence, not a legal matter. It's political, not legal. There was an argument in terms of the causal proximity or lack of between the children and the decision by the minister. And there was an unwillingness, and it's a kind of variation on the separation of powers argument, that you can't go around limiting ministers' choices like that. Courts do not have the power to limit choices by ministers. It would be incoherent with their remit, with their powers, for some of those powers to be taken off the table. So what's really interesting in this case, as far as I'm concerned, and again, I'm glossing over lots of interesting and knotty legal details, is the recurrence of this word coherence. The whole decision is dotted through with this idea of coherence. And I read that and I thought, actually, now we found our master principle. I've just told you before there is no master principle in law. And I thought, actually, no, we found our master principle. Our master principle is coherence. Then when we ask the state to be reasonable, or when we ask the state to think in all things considered way about what the right thing to do, we're asking people to be coherent. Nothing more, nothing less. That's the master principle that law is going to give us. But on a closer reading, it seems to me that again, that's just not the case. There are no master principles. And coherence, unfortunately, floats between three quite different ideas, actually, in the decision. One, coherence, legal coherence, says no conflicting rules. If you've got two rules that conflict, one of them's got to be defeated. Very simple, straightforward, basic legal principle. You've got two conflicting rules, one's got to be defeated. That's coherence. There's this other idea of coherence, political coherence, which is to say that there should be a proper separation of powers between the legal and the political. it's incoherent for the courts to go around saying what ministers can and can't do. There's a separation of powers issue there. They need to be kept separate. So that's coherence. And at the same time, there's also this kind of moral idea that the court should, everybody should be making an all things considered judgment about what the right thing to do is. And you and I, we all know that the right thing to do is not to grant coal mining licenses. We know that. But that's not the idea of coherence that won through. It was the political idea and the legal ideas of coherence. So I've rattled through that with unseemly haste. But the point there, I think, is it's really worth reiterating. No master principles, no all things considered judgments in law. Okay, breather, pause. The dramatic effect. I'm going to change the focus again now. We've looked at these cases, we've looked into the courtroom, we've peeked behind the veil of how lawyers and judges think, and it's not very pretty, and it's perhaps not what we want. The question is why? So we're going to go back and do some more philosophy. Why does law do these unsatisfactory things? Why does law not give us all things considered coherent policy? Why does law not do the right thing? Why does it just stick to doing these less, probably admirable, but less ambitious things in terms of coherence and principles? The answer to that is found in how we understand law in opposition to other phenomena. This is what legal philosophers do. Real lawyers do boundary disputes, right? They deal with hedges and whether people's trees are intruding into your garden. That's one kind of boundary dispute. In legal philosophy, we do boundary disputes, but we do it between different normative fields. This is our back. This is our contribution to the world, modest though it is. And so to understand what's going on, we need to separate law from politics, from morality, and ultimately, I'm going to say, from nature. The first thing to say is that politics and law are being held separate in those decisions, as it should be. Now, it's not to say that there aren't connections. Of course, there are connections between politics and law. Political institutions make laws. But they are different fields. The fact that we worry about the politicization of law is symptomatic of the fact that we think they are two different things, and we don't want law politicized. But they really are two different things, and here's a couple of reasons why they're two different things. One, law is about coordination. It's not really about pulling together around a single goal or a single plan. There's a call back to the title of my paper. We're not when we're dealing with law, we're not working together to a single plan or a single goal. We're just working in coordination with one another. What's a paradigmatic law? Paradigmatic law is drive on the left. Now, you drive or ride on the left, and you want everybody else to drive or ride on the left. I don't care where you're going or what you're doing when you drive or ride on the left. As long as we all do the same thing, we can all stay safe and we can all do what we want when we get to our destinations. That's law, right? It's making sure that we can do what we want, but we don't hurt each other when we're doing it. That's coordination. It's not cooperation, it's coordination. And that's what we politics will give you cooperation, or at least it'll try to, but it's not really so concerned with cooperation. And let me call back now to this idea of conservatism and presentism. I said that law is it's partly presentist, partly not presentist. It's certainly conservative. Law is certainly conservative insofar as it tends to find authority in the past decisions, past lawmaking events. So in that sense, it is conservative. There's no denying that. But when we think about presentism, actually, I want to say that politics is much more presentist than law, because particularly in a democracy, when you're on short-term electoral cycles, right? Every impulse pushes towards presentism, towards making promises to people today and worrying about the costs later. It's about cakeism, right? What was cakeism? It was about saying you can have everything without any costs. You can have great public services and without raising taxes. You can have sustainability without decoupling from fossil fuels. That's cakeism. That's a kind of presentism. That's what politics does. And the point of law is that it holds people to account from that. It's a counterweight to that presentism. So let me stress, law and politics are two different things. And I think it's really important to stress that certainly law is annoyingly, dangerously, illegitimately conservative sometimes, but that's less of a problem, less of a pathology in some ways than the presentism that you get from politics. Second, a second opposition that we saw in the cases is between morality and law. If morality is an all things considered judgment about the right thing to do or the best thing to do, law is not going to give you that. Law is going to give you a decision about people's rights and their duties in the light of a bunch of rules that are given weight and interpretation on the basis of a bunch of principles. But it is not going to give you an all things considered morally justified outcome or decision. There is such a thing as legal morality, but that's a different animal. Legal morality is about reasonable expectations, it seems to me. It's about making sure that you don't place excessive demands upon people. Now, what excessive means and what demanding means is open to interpretation. But roughly speaking, and this is symptomatic of law's presentism, the courts will have an implicit view of what a reasonable sacrifice is for a person to make. It might be reasonable for you to experience certain kind of losses, but it's certainly not reasonable for you to have all your property stripped from you and given peremptorily to other people who need it. Maybe morally speaking, that's right to do, but legally speaking, that's not how law rolls. Nevertheless, I mean, this idea of reasonableness is not just, it can be just some kind of ideologically shaped idea of what our expectations are in an affluent state in the 20th century. But reasonableness can have a thicker and more defensible meaning about just, or implies can, not making excessive demands on people, not pushing people beyond the bounds of what can be reasonably expected of. That's what legal morality is about. It's not all things considered morality. And a final opposition. And then we'll be on the home straight, promise. Typically, we oppose law to politics and morality. What's less frequently done, but I think increasingly important in the 21st century, in the Anthropocene, is to understand how law is, and perhaps always has been, and maybe always will be, defined in opposition to nature. Change of pace, storytelling voice. Pre-Socratic philosophers, the sophists, were wandering around Greece sometime in the 5th century before the Common Era. The sophists were itinerant teachers of philosophy. They subsequently got a bad name, and that's why we have sophistry as a pejorative term. But once upon a time, they were relatively respectable philosophers, and they had one big idea, that physis, nature, is in opposition to nomos, law or convention. That laws, nomoi, conventions are there to constrain, control, to weaken nature, and that nature is always good. By extension, law is always bad. So maybe the fact that it weren't a very enduring philosophical movement is the fact that they put these two strict value ideas, nature good, law bad. I mean, that's just not sustainable. I mean, you're not going to be able to follow that one through. There are clearly ways in which nature can be bad, and there are clearly ways in which law can be good. But they told a really important and enduring story, one that we still hear today in criticisms of law, in critical legal studies, that says that there is something illegitimate about law, that law tends to involve the suppression of natural impulses, that law is about imposing a kind of unnatural uniformity on people, an unnatural uniformity on human nature, that law is an institution like other institutions that is a bulwark against nature and the contingency of nature, and it's a foolish human thing because you cannot build a bulwark against nature. Nature will always win. These criticisms, these are perennial. They've been around since the Sophists, and they are still alive today. Of course, in the Western philosophical tradition, the Sophists were defeated. We all have Socrates, Plato, and Aristotle to thank because they defeated the Sophists, and they showed that physis and nomos can be reconciled. Aristotle, with his pre-Darwinian biology, says, look, humans are a particular kind of unchanging species. We are a social or a political animal. We have to live in conjunction in societies with one another, and therefore we need laws to make sure that that happens. So there is a reconciliation between human nature and law. And that's the orthodox position, right? The Sophists were defeated. Aristotle, Plato, they proved that law and nature are actually reconcilable. Notice that Aristotle slightly changed the subject. Aristotle proved that law and human nature are compatible, or he tried to prove. But that's not what the Sophists were saying. The Sophists were saying that nature as such and law are incompatible. So whether Aristotle won or not, or whether the Sophists won, depends on whether you accept him, as it were, changing the subject from nature as such to human nature. Okay, so that was 5th century BCE. Jump to the 21st century, and there are still two live groupings in the philosophy of law that are still working over these themes. So we've got the natural law tradition that is derived from Aristotle, but it's still alive today. And the natural law tradition, despite its name, is all about human nature and the fact that law must reflect natural, reasonable human expectations that are tied to human lifespans. My interests go no further than my lifespan, or maybe my children's, but not much beyond that. And the natural law people say that's fine, that's just right, that's natural, that's what should be happening. Law should be quite conservative in that respect. And on the other hand, you have the wild law people, earth law or earth jurisprudence. Now, these people are going to insist that we can encompass nature within law. There's no incompatibility between law and nature, that we can bring in non-human sources of value, grounds of value into the law. There's no contradiction there. We can and we must revolutionize law so that we can give genuine value to non-human nature, not just commodify nature or turn it into property, but actually genuinely recognize the value of nature out there in the world. Whichever of those is right, and I actually think there's an important element of truth in both of those positions. What they agree on is that normally when you find law, it exists in opposition to nature as such. The natural law people are saying human nature is the important thing. Human nature gives us societies, and that keeps us safe from nature as such. And wild law people are saying when you encounter law now, it tends to be all about all value claims are filtered through human interests. Law is always opposed to nature. What have I just done? I've suggested that law has to be understood in these oppositions, in opposition to politics and to morality, but also in terms of an opposition to nature. And all of these elements are why we can and we do and we should find climate decisions unsatisfactory. Law is not there to give us all things considered judgments. It's not there to give us moral leadership. It's not there to foster cooperation. It's not really there to acknowledge non-human nature and values outside human values. That's just not what law is doing, and arguably never will. And we saw that in the operative elements in the cases, didn't we? There is the thirst for coherence and all things considered judgment, but don't expect clear moral coherence from law. It's not what it's about. And don't expect any master principles to come in and to dissolve all our problems and resolve everything in a particular way. For every sustainable development, there is going to be a parliamentary sovereignty. For every precautionary principle, there is going to be the separation of powers. There is always going to be the play of principles pointing in different directions. What I haven't done, and I'm not going to do, is say precisely how all of this feeds into wider currents of general jurisprudence. Suffice it to say, I mean, there is a theory of law that's called the planning theory of law, and it says that law is all about planning. The way that you plan your lives, institutions plan, that's exactly the core of understanding law. All the ingredients that I've given you so far, I think, add up to a falsification, or at least a deep reasons to be deeply suspicious of the idea of law as planning, particularly planning for a good, sustainable future. Law is not going to give us a roadmap. It's not social engineering. It's closer to agency architecture. That is to say, it helps us to make certain kinds of non-presentist decisions, but it's certainly not planning for the future. So I'll leave you with just a couple of loose ends and extra thoughts that maybe to add into the mix if I hadn't given you enough already. Law is always going to be part of the wider issues of practical reasoning, practical philosophy. That means it's going to hit a bunch of paradoxes and problems in terms of non-identity, repugnant conclusions. Planning for the future philosophically as well as practically is a massive headache for us as a species. Any kind of attempt to plan for the future is going to hit all sorts of paradoxes. Good law might well end up, what counts as good law today might well end up being bad law for people tomorrow. There is no escape from that. But, and here's the good news, bad law can still be useful law. Politicians do line up and tell us oftentimes, no law is better than bad law, particularly if it's foreign law of some kind. No law is better. We're not going to sign that treaty. No law is better than bad law. I disagree. I think very often bad law is often better than no law, not least because the law works itself pure. We take it to the courts, we litigate it, and we fix it, and we make it better, and it improves incrementally over time. So I'm going to leave you with that slightly optimistic note that law is no guarantee of intergenerational justice or climate justice, but it does at least get better over time.
Many thanks for the fantastic talk. And now, the online audience can put the questions in the chat, but I will also like to open the room for questions, if there are any. Yeah.
Thank you very much for that inspiring talk. My question is about the recent court case in Vermont, in case you have heard about this, where environmental activists were taking the oil industry in Vermont to court over the climate change impacts and the damages arising from them. And the court basically found that oil companies, in their judgment, they argued oil companies had been fully aware of the damages that the fossil fuel burning does to the climate system, and they deliberately misled the public over decades by trying to discredit climate science. Therefore, they would be held legally accountable for the costs from climate change impacts to the public. That, to me, is a game changer in the court cases that I read about in the newspapers. And I wonder whether you have observed in your own research a shift in the way that courts are dealing with climate-related problems, like in Switzerland. You mentioned the Switzerland case.
Thank you, much appreciated, and thank you for your kind words. I'm going to respond briefly and say I think the evidence is mixed. I think it depends a bit on the forum as well. Some fora are better equipped or better placed to make ambitious or radical decisions. And with those kinds of cases, we always have to be careful to be mindful of the route of appeal upwards. And one can imagine a Supreme Court, a very conservative Supreme Court in the United States, taking a different view of the law. That said, I mean, international courts or internationalized courts are sometimes in a position to be a bit more radical, albeit they have less purchase as international courts. They're not in such a position to change the law, to alter the law. They can recommend, but they can't really change. So all that by way of saying, I need to go away and read that case and look at the details. But I would certainly want to insist on a bit of a mixed picture, and certainly the importance of looking at the difference between domestic courts and international.
Any other questions?
A similar question to the earlier one, but it's focusing on the UK example, the May 2024 High Court decision. If you've already discussed it, apologies. What your reflection is on that? It is a domestic.
Yeah, thank you very much. The reasoning there in the UK court, so we've got some very good activist groups in the UK, Good Law Project working along with Greenpeace, and they use administrative law to hold the government to account. They have been successful, and for reasons that are very analogous to the Swiss case that I talked about. That is to say, the courts don't wade in too much into the specifics of the science or causality, who did what, but rather it's a question of whether the state has taken reasonable steps and specific enough steps to reach the goals that it has explicitly committed to. And the string of successful cases in the UK are related to the fact that our political parties are very happy to sign up to very broad commitments in legislation, but when it comes to pinning themselves down to detailed commitments, they will not do it. And the courts have been looking through the details and the ways in which the commitments are calculated, and they're found wanting. There's a great deal of conjecture. There's a considerable lack of specificity. But just a footnote to this, and lest I'd be accused of just beating up my own government. One thing that the UK does, which is endemic, and it's not just UK, is including certain kinds of technologies in their net zero planning that are not proven at scale. And this is rife in the UK's policies, but it's rife in various other cases as well. It's factoring in unproven carbon sequestration, essentially, that can't be done at scale. It can't be done at scale now, and perhaps maybe never can be done at scale. Even the IPCC does a little bit of this, and is quite generous in terms of what it assumes can be done in terms of carbon sequestration. So it's essentially, thank you. The UK falls down on a lack of detail, as the Swiss did, but also too much reliance on unproven technologies.
Mm-hmm.
Thanks, Steve. I wonder. So I'm just reflecting. It strikes me then law can, if equipped, plan. Could we turn the question to the, can we answer the question, your title is Law is not planning. Could it be reframed, law is capable of planning, why isn't it?
Yeah. It's an accusation, right? It's a, well, it's not planning. Why are you not planning? Yeah, I think that's fair, as long as we're seeing law working in concert with and in conjunction with a wider political and social movement. And there's a good division of labour there, right? The law keeps an eye on the details, make sure there's sufficient reasonableness in the steps that the state is taking. But it is up to the executive and legislature to make specific plans in the light of where the state is now. That's why the dissent in KlimaSeniorinnen is quite powerful. And I must admit, I read the dissent first. So the dissent is like the disagreements, the fun bit at the end. You get the dreary kind of everybody agrees for 200 pages, and then you get the snotty UK judge at the end and says that this is not fair. This is a political matter. Well, yeah. I mean, I'm treading on into your area of expertise now. But the point is that dissent reasonably argues that this has to be a holistic thing. It has to be legal and political and social, and the law doing it alone can backfire. Yeah, in essence, yeah. But I'm still a bit suspicious of the idea of planning. I don't. If we want a plan to save the planet, I'm not going to look to the courts. Courts might help. I'm not going to look.
We have time for one more short question.
Oh, okay. I don't know how short it is, but I don't think it's even long. So, I'm a bit worried if we say that law is not about planning, that it's saying that law is quite neutral, and that law is, it can never be good or bad. It just is. That makes me think about structural injustice that law creates and how to resist that structural injustice if law is just neutral and is never good or bad. It's just about coordinating things that are happening. And isn't that based on a view of human nature as well that's very, well, liberal and not like forward thinking? So there are different views of human nature, and it's getting a very long question. So I'll stop there. But there's lots of ideas that are coming up, but the neutrality of law and law is not planning is a thing that I worry about.
Thank you. No, I worry about it too. I'm certainly not wedded to an idea that the law is immune from criticism. Simply by virtue of being law, that it has a certain value. There's nothing to stop us criticizing law. We should both internally and externally, right? So we use internal resources of law to criticize decisions, and we use external resources, and we should do that vigorously, passionately. So my position does not preclude that.
Why would be if it's just that coordinating? That's cheap.
No. There's a clarification.
Yeah.
Follow up. Well, it's not just law. I mean, it is. It's lots of things. I mean, it's principled decision making as well, and there can be good use of principles and bad use of principles, and there can be principles that do enforce the status quo, and there can be principles that hasten progressive change. So nothing I've said precludes internal or critique or external critique of law. And if I've said anything that sounds like I'm an exclusive positivist and I'm valorizing law and questioning law, then I apologize.
Many thanks. With this, we have no more time for questions. Thanks to the audience. Thanks to the online audience. One last round of applause.
You're too kind. Thank you. Thanks for coming.